My name is Jed Temple. I'm a solicitor that works in the Civil Litigation Dispute Resolution Department at Church of Solicitors, and I work in the Fareham office. If you're a landlord of a residential leasehold property and you find that your tenant's in breach of the terms of the lease, you might actually look towards the forfeiture provisions to leverage a solution. Forfeiture is essentially a remedy for the landlord to re-enter or repossess the property and bring the lease to an end. Now with forfeiture, there is obviously a standard process that landlords can go through, but it really does depend on what the objective is. For each different scenario, you might have a different issue that you want to try and tackle. So if you're purely looking towards a forfeiture, you might run through some standard processes, but if it's more a tool to try and enforce the other covenants within a lease, then it would be worthwhile getting some early legal advice, just so that you could talk through those issues with your solicitor and they can give you some advice and some strategy on how to move forward. Firstly, you need to have a look at the terms of lease to see whether you have the right to forfeit a property, and if it's not there, then you essentially don't have that right and it's not available to you. Just be careful with the forfeiture clause when you find it, and you have to make sure that it's actually quite clear. There's no ambiguities, because if there are ambiguities, the courts aren't going to write any inferences into the lease for you. It has to be very clear, and it needs to address the particular circumstances of the breach. With the standard processes, there are special notices that are required, and it's depending on what kind of breach you're looking at. If it's a non-payment of rent, there's a notice called the Section 166 notice, and you need to serve that before you can forfeit a property. And if it's a breach of any other term, then there's another process which involves you making an application to the tribunal to get a determination of breach. That's if the tenant hasn't admitted to that breach. So you go to the tribunal, you get a determination of breach, then you'll have to serve what's called a Section 146 notice, and then once the reasonable time has expired and the tenant is still in breach, then you have to apply to the courts for a possession order. So as a landlord, you need to make sure that as soon as you become aware of a breach, you don't inadvertently waive your right forfeit. So once you learn of the breach, you have a decision to make. Do I forfeit or do I continue the lease? If you do anything which is an act in continuance of the lease, such as making a demand for rent or accepting rental payments, then your tenant can say that you've decided to continue the lease, and in doing so you've waived your right to forfeit. You might want to check as well if there is a mortgage on the property, because if it's a non-payment of rent or you're owed some kind of money, you might find that you can get in touch with the lender who may wish to pay the debt to protect their security over the property. Just keep in mind that courts don't favour forfeiture. It's quite a draconian measure, and if a tenant applies for relief, then the courts will often try to find a way of granting that relief. Even if forfeiture is avoided, courts don't grant the forfeiture. You'll often find that there are clauses within the lease that the tenant will have to pay the reasonable costs of the landlord in bringing the claim. It is quite important to get early legal advice, because you want to make sure that all the circumstances of the breach are considered and the objectives are considered, and that the strategy is put in place to make sure that you start off on the right path before the parties get entrenched in and so many traps that you can fall into as a landlord trying to go down the forfeiture route. So it's really important to seek legal advice so that you are taking the right measures as you look to forfeit the lease. So here at Churches, we've got a lot of experience in dealing with landlord-tenant issues. If you have an issue with your residential tenant, feel that they're in breach of the lease, then please feel free to get in contact with us, and we'll certainly be happy to take your call and talk you through any of the circumstances of your concerns or complaints.